Good afternoon, everyone. My name is Delegate Maggie McIntosh. I chair the Appropriations Committee. And this afternoon, we're going to have a number of bills heard in the Appropriations Committee. The bills numbers are House Bill 494, House Bill 743, House Bill 744, House Bill 470, House Bill 438, House Bill 458, House Bill 379, House Bill 406, House Bill 511, and House Bill 751. And we will hear them in that order. I want to remind everyone that's coming before us this afternoon that the sponsors are given ample time to introduce their bill, and the witnesses following the sponsors either for or against are given 2 minutes to give their testimony. So please summarize your testimony. One further announcement that I need to make, our committee staff has informed me that we have had a number of people who have called or emailed or texted in some way communicated with the committee. They're late signing up, and so we have allowed people who've been late signing up. But the number of people is growing exponentially. So we are going to have to abide by the same rules that all the other committees are abiding by. And if you don't sign up on time, we are sorry that we cannot let you in the door. You'll have to submit your testimony in writing, but we do want to hear from you. All right, with that, we're going to begin with Delegate Jackson, Public Safety, Police Athletic League Grant Fund.
All set?
All set.
All right. Hello, Madam Chair McIntosh, Vice Chair Chang, and members of the Appropriations Committee. Thank you for having me. For the record, my name is Delegate Carl Jackson here in support of HB 494. This bill is similar to a bill I brought before you last year. Additionally, there are 2 amendments that I have introduced to bring this bill in line with the amended Senate crossfile, which was recently passed by the Senate. As amended, HB 494 would require the governor to include in the fiscal year 2024 budget an appropriation of $500,000 to be administered through the governor's Office of Crime Prevention, Youth and Victim Services for grants to be awarded to police athletic league programs, also known as PAL, throughout the state. To show the value and importance of the police athletic league programs, HB 494 will also include the governor's Office of Crime Prevention, Youth and Victim Services to submit a report to the General Assembly detailing the potential impact of these programs have on local communities once implemented, as well as track the number of these programs that are operating in the state. At the request of this committee after last year's hearing, the definition of police athletic league program has been expanded to include any program that is operated by local governments or organizations that is designed to build relationships among youth, police, and the community by offering educational and extracurricular activities to participating youth. This expansive definition will allow many worthy organizations and local government programs to be eligible for this grant that might have not qualified under last year's bill. My passion for this bill comes from a very personal place because I am a proud product of the PAL program. PAL gave me a place to go to after school, on the weekends, and during the summer months. That was a safe space for me and the kids in my community. During the school year, I would go to the local PAL Community Center to receive help with my homework and participate in athletics. During the summer months, all the kids in the community would be at PAL from sun up to sundown, just being kids. If it had not been for PAL, I can only imagine how I would have spent my time and what trouble I may have gotten into. As I got older and thought back on all the benefits of the PAL program, I realized that the officers that ran the program had a major impact on my community. They knew all the kids and their families, which helped foster mutual respect. The officers looked like me and the rest of my community, and we came to see them not just as law enforcement, but as trusted leaders in the community. They helped show they help show us a different side of what good policing looks like. And before I end, I would like to share a quick photo, if I may. If everyone can see, I shared this photo before, but I'll share it again. The story behind this photo came about, they had a campaign called Cows Pals back then when I was in the PAL program. And so kids from all over Baltimore City had to audition to be a part of this campaign. And part of the auditioning process was for us to smile. All we had to do was smile for long periods of time. And they picked, you know, the kids who was smiling. And I was fortunate to be one of those. But it was a campaign for across the city to spread the news about the PAL program and all the good that it was doing. And it was called Cows Pals. So just wanted to share that story and share my picture and with the Iron Man there. And thank you for your time.
Thank you. Are there any questions of the sponsor? Any questions? I don't see any. Oh, no, I do. I'm sorry, Delegate Beitzel.
Yeah, I just want to ask Delegate Jackson, thank you, Madam Chair. As Delegate Jackson, he's referred to that baseball player there as the Iron Man. Would you identify him for those people that don't know?
For those who don't know, it's Cal Ripken Jr. Thanks for the question, Delegate.
Thank you.
All right. Any other questions? Now I meant Delegate Jackson, were you part of the PAL program while you were attending Herring Run Junior High School?
I was attending Northeast Middle School.
Ah.
Yes.
You went
yes.
across the street, huh?
Yes. Yep.
Yeah,
I sure did.
All right.
I sure did.
All right. Thank you very much. And have a great day. Okay.
All right. Thank you.
That concludes the bill hearing on House Bill 494. We're now going to move to House Bill 743. Delegate Lehrman, you have two bills.
I do, Madam Chair.
Yeah, go ahead.
Great to be with you. I bring you bills as the co-chair of the Joint Committee on Pensions. So if you'll bear with me, we have two Joint Committee on Pension bills today. I'll start with HB 743. This is not a system requested bill. This is from the Joint Committee itself. This fall, we had testimony from our teachers union and others who talked about the incredible difficulty that our school systems are having hiring substitutes and hiring teachers. And one of the provisions in our pension law requires that you cannot take your full pension or accept full pay when you're receiving your pension. So after you retire, a retiree who receives a retirement benefit from the pension system, SRPS, may be reemployed, but that retiree may not be reemployed within 45 days. And then there's a cap on how much they can actually earn. There's an earnings cap. And that acts as a deterrent sometimes to these great professionals who have years of experience. So this bill, with an amendment that you all have, will simply remove that cap for up to 25 teachers who go to be reemployed per school district. So as the bill went in, it wasn't capped at 25 teachers. We believe that a cap at 25 teachers per school district works. And we've talked with MSEA and others about this as well. And they believe that cap is appropriate as well. So that is what this HB 743 is. And I move favorable. I hope you will grant a favorable movement on it.
You're going to move favorable already, huh?
Yes, I'm moving it already. I feel like I'm part of the committee. I don't know why.
Yeah, welcome back. Any questions of the sponsor? I see none. All right, you want to go on to your next bill?
Great. So the next bill is a system requested bill, HB 744, and I have the amazing Ann Gothrop here as well. So this is a bill, it has several different provisions to go through sort of cleaning up some of the errors we found in state law. So the first thing it changes is it specifies that only active, in other words, currently employed members of the SRPS may be elected as trustees. to the system, representing their system. So that is one cleanup. Number two is that it corrects an inadvertent drafting error to clarify that survivor benefits for retirees who are enrolled in the deferred retirement option program are the same as those for retirees who die when they're not enrolled. Number three, it adds an exemption from a benefit offset for retirees of the correctional officers retirement system who are reemployed as parole and probation officers, to be consistent with a similar exemption in other systems. And then finally, it repeals an obsolete provision allowing members of the judges retirement system to purchase credit for some prior employment. So those are the four things that this corrective bill does, and I hope you will consider giving it a favorable motion. Thank you.
Thank you. I see no questions, but I goofed on the last bill and overlooked the Maryland Association of Boards of Education, who have someone here would like to submit testimony, and I believe in person.
Yes, hello, Madam Chair.
Yeah, there you are. Alexa, I'm very sorry.
No problem at all. I'll go ahead. Good afternoon, Madam Chair and members of the committee. My name is Alexa Thomas, and I'm here on behalf of the Maryland Association of Boards of Education to voice our strong support for House Bill 743. In light of the struggles amplified by the COVID-19 pandemic, school systems around Maryland are facing critical shortages of highly qualified teachers and educational staff. These school employees are essential in providing high quality education to our students, as well as leading as administrators within our schools. House Bill 743 would simply provide educational staff, such as classroom teachers, teacher mentors, and principals, with a pathway to reemployment once in retirement. Retaining and rehiring experienced educators in these fields is critical to student achievement, and these professionals are essential to the successful implementation of the blueprint for Maryland's future. This expanded opportunity for retired teachers and principals to be rehired would extend through June 2024. Through the passage of this bill, as well as through teacher retention initiatives outlined by the blueprint, MABE anticipates that many of the shortages school systems have faced since the onset of the pandemic will be rectified. In conjunction with this bill, these reforms and investments will have a positive and lasting effect on Maryland's ability to recruit, educate, and retain the best educators in our nation. And for these reasons, MABE urges you to pass the favorable report on House Bill 743. Thank you.
Thank you. Thank you very much. Are there any questions now on either bill? Very good. Thank you very much, Delegate Learman, for being back in appropriations.
Thank you very much, Madam Chair. Great to see you all. Have a great afternoon.
Thank you. We're now going to move to House Bill 47, Delegate Acevera.
Thank you, Madam Chair. Good afternoon, colleagues. For the record, Delegate Acevera here to present House Bill 470, the Maryland People's Fund reintroduction. So I won't say too much other than we have seen just the positive impact of direct cash assistance. This is it. This is something that we should be looking at. The pandemic has showed us that the direct cash assistance not only helps low-income folks, but those who are struggling to make ends meet and need the assistance, particularly to meet their basic needs. And so what House Bill 470 does is it creates the Maryland's People's Fund, and in essence takes a portion of the estate tax, places it in this fund for investment, so that long-term what we could do is build out a guaranteed income or universal basic income program, so that at some point the goal is that every month, every Marylander would receive, no questions asked, $500 a month to meet your basic needs. And I think that's something that we can do. This is not new. Another state is doing it. Just so happens to be a Republican state. Other jurisdictions are doing it. Other countries do it. So we've had a lot of people advocating for direct cash assistance, from the comptroller to leadership of the General Assembly to even folks outside. This is something that we can make long-term and ensure that folks are able to make ends meet. So I hope that we'd give it some serious consideration as part of our effort to put a dent and to hopefully one day end poverty. So thank you all so much, and I ask for a favorable report.
Thank you. Delegate, I think the first time you brought this bill before us, you cited either a city or a county, or I don't think it was a state that was actually implementing this. And I was wondering, and subsequent to your testimony, I think I heard about it on one of the national news shows, like 60 Minutes or something of that sort. But is there an update on that quote experiment?
Yeah, so I'll point out that universal basic income or guaranteed income is something that could be explored at the municipal or the county level, but it's a program that largely works effectively at the federal and at the state level. In terms of local jurisdictions, you have the city of Stockton has done a pilot program,
Right.
But it's a public-private partnership. That's what municipalities and counties do because they aren't able to really run and sustain this program the way state governments can do. An example is in Alaska, where they do have a guaranteed income program that they tie to their gas, oil or gas reserves in Alaska. And so I'll also point out my county, Montgomery County, recently passed legislation to create a guaranteed income pilot program for 50 of the most low-income households in our county. And really, cities and counties are the laboratories for universal basic income or guaranteed income. They're basically showing us why we need to do it at the state level. So my hope is that Maryland would follow Alaska's lead, and we would look at this. And this is something that we can put as part of our poverty elimination package.
Okay, thank you. We do have someone signed up. Oh, Delegate Kettleman, you have a question of the sponsor?
Yeah, just a quick question. I know this is something I believe that like one of our great economic professors suggested doing with the guaranteed income. However, it was paired with getting rid of all the other programs that we have. So is that part of your plan?
That may lead to data loss and identity theft. The computer lock is aimed to stop illegal.
Okay, all right.
Oh,
That was not me, by the way.
I know, we apologize.
No identity theft over here. But Delegate Kittleman, to your question, I mean, I always appreciate that question every time I bring this bill. But this bill
Glad
is
to help.
yeah, this bill is not intended to supplant, but rather to supplement the programs that we have right now to help people. This is about, building a welfare program where we could ensure that we're giving people a hand up so that they can meet their basic needs. And that's all that it is. So I'm not trying to cut any other programs. I think what this pandemic has shown is that Americans are really, really vulnerable right now. So this is about strengthening existing programs and adding new ones that work.
Could I just follow up with that? What I would like to know, whenever we put social programs into play, what are we trying to achieve? Because we have a report that DLS publishes called Public Benefits, where they list all of the benefits that are available and compare people who don't work at all, who work minimum wage, and then who have the regular wage. And the benefits that are available are very, very comparable. I realize that housing makes that not so comparable, but it seems to me it might not be a bad idea to know, how much more, how are we spending this money, and where is our goal to get people to?
Yeah, well, Delegate, thanks for the question. The goal is poverty elimination, and this is one of the tools to be able to do that, right? Studies after studies show that, by giving people money, they tend to spend it on their basic needs, and they tend to spend it in the communities that we live in. So if anything, it circulates the economy, and it's good for businesses, it's good for communities, and I would hope that we would all agree with that. I would also say that this is not a new idea. I'd ever find myself saying this, but we should follow the lead of Alaska, right? Where Republicans over there, libertarians, I might add, of a particular variation of Republicans, managed to pass similar policy, but tie it to their oil reserves, gas reserves, I'm sorry. And so because we are not an extractive state, we obviously have to figure out a way. And so that's the goal here. You know, we talk a lot about how we eliminate poverty. This is one of those ways, and it's something that's accepted by both folks on the left, the right, the center. It's about ensuring that people have what they need to meet their basic needs.
Well, I wish we had kept our opportunity to have money from fracking, so we could follow Alaska. Thank you.
Well, I think we can find other ways, but I'll also add to studies show that the average Americans cannot afford a $500 or more unexpected bill, right? And I'm just trying to ensure that every month folks have $500 to meet their basic needs. And so it's only gotten worse with the pandemic, right? We see the impacts of direct cash assistance when we gave out that stimulus check. What did folks do? Right? Majority of it was spent in communities on basic needs to help keep small businesses open. If we can continue that and do it on a monthly basis, you know, it could have such a powerful and just a powerful impact. So, yeah.
I will say, we do have another question, but I will interject and say that I think it is interesting following the pandemic and the relief acts, and even our own relief act, where we, both federal government and state government, did do cut checks for families. I do think it would be interesting, and it is interesting to see the impact it had on those families. As an example, I was told that the child tax credit, which is now poof been eliminated, reduced child poverty in this country by 40%. I mean, that's astounding. And the fact that Congress let it disappear, I guess, once you know what it actually achieved, is even more astounding to me. That's, you know, Delegate McIntosh at work here, just talking away. But Delegate Grice has a question of the sponsor.
I do. Thank you, Madam Chair.
You're very welcome.
So we mentioned Alaska, and I guess what they had set up in Alaska is the proceeds from their mineral royalties. What they do is they take those proceeds and they reinvest them in stocks, bonds, mutual funds, that sort of thing. And so the interest that's earned on those investments, they use that to pay out into this program. And this was developed, I think, in the 1980s, maybe. So this is a program that's been established for quite a long time. So we're not taxing the taxpayers, and we're not redistributing taxpayer money in that situation. So it's quite different than what we have in this bill. I don't think you have anything in this bill as far as a revenue source where we're actually earning interest, and then we're redistributing those proceeds, right? This is quite a bit different than what they have in Alaska, is what you're proposing. Is that correct?
Yes, it's definitely different. As I mentioned, Delegate Bryce, we're not an extractive state, so we got to find ways to fund it.
And this bill does not have a funding source other than potentially general fund tax dollars. Is that correct?
Actually, no, it does. It's connected to the estate tax, if I believe. So
State tax.
I'm sorry.
Estate tax. Yes.
Right.
Mhm.
Right. And so, you know, as I said, I mean, I don't need to tell you, I mean, Maryland's, we have a pretty archaic and regressive tax code, and this is just sort of one of the ways of you know, addressing an issue while also really addressing two issues.
Thank you.
Appreciate
Thank
it.
you. Okay, we're going to now move to Christopher Apple, who's here on this
Thank you.
bill.
Thank you very much, Madam Chair, Mr. Vice Chair, committee members. Good afternoon. I am Chris Apple. I'm a resident of Columbia, Maryland. I am 36 years old. I'm a software engineer. I make six figures. I've owned my own business. and we're looking to buy a house right now. By all measures, I've achieved the classic American dream. And I just want this committee to know that there are people like me who want this bill. I think I've worked pretty hard in my life. I don't mind at all that my tax dollars might be used to help someone in need. I know that this bill pulls from the estate tax, but I wouldn't care even if it did come out of my own pocket. Maryland has one of the lowest poverty rates in the country, about 9.4%. But that 9.4% represents over 500,000 Marylanders whom the current system is failing. And to me, that's a catastrophically huge number. I don't want to see any of my neighbors in poverty. And my American dream is living in a place where no parent is struggling to take care of their kids. I think this bill can do that. I'm not a lawyer. One potential amendment I'd like to see, to suggest, is a list of limitations on how the fund might be used. I envision it being focused on social programs, but I'll defer to the sponsor's judgment. I just wouldn't want to see this money used for anything that might disagree with the spirit of the fund.
Thank you.
I think this bill provides a framework we can use to lift each other up. I think it helps us focus more on care and less on competition. Competition can sometimes divide us, but care unites us. I respectfully urge a favorable report. Thank you, Madam Chair.
Thank you very much. That appears to conclude the bill and the testimony. Thank you very much, Delegate Acevera. We're now going to move to House Bills 438, 458, and 379, all of whom are sponsored by Delegate Corman.
Thank you, Madam Chair. First, let me apologize to Delegate Grice's blood pressure that we're doing a WMATA bill and a collective bargaining bill back to back when he's already back here and no longer in Florida. I apologize for the timing, but I don't set the committee schedule. In all seriousness, colleagues, the first bill before you is the WMATA Dedicated Funding Amendment Act of 2022. As most of you recall, back in 2018, this committee and the full General Assembly passed a bipartisan regional bill on dedicated funding for Metro. When we did that, we, as a region, did not all act the same. And what I mean by that is here in Maryland, we put a growth escalator on our existing capital contribution to Metro. In DC, they put a growth escalator on the dedicated funding portion. In Virginia, they did neither. This bill is part of regional discussions with DC and Virginia that Senator Feldman and I have been involved with to try to bring some more rationality to that and also ensure that the dedicated funding can continue to be bonded off of. That was the big purpose of the dedicated funding, was to create a bonding stream for WMATA so that they could do more of their capital programs. I attached for you to my testimony some slides that show some of WMATA's progress on capital. Two things happened in the past 6 or 7 years or so. The first is that the general manager, who's Paul Wiedefeld, who some of you know prior to going to WMATA, worked at MTA and did 2 stints at BWI, put in a new capital programming system to ensure that Metro was using the dollars they did have more effectively. And then, of course, we amped up those dollars in 2018 with our bipartisan regional contribution. And you can see there the job they've done chipping away at their backlog and also improving safety and reliability of the system in the slides there, including fewer arcing insulators, which means fewer track fires and more rail cars and buses in service at a given time. So again, the purpose of this bill is to remove the growth escalator from what I call our sort of pre-existing capital, which is $143 million a year, and instead put it on the dedicated funding source, which does start at a higher level of $167 million a year. It is contingent on Virginia and DC doing the same. As I said, DC actually already has this provision. Virginia, I do not think we'll be acting on it this year. So I think in Virginia, it'll be a future year discussion, but I'm hoping that we can sort of put this to bed in Maryland, although again, it will not go into effect until Virginia does the same. So that's the point of the bill, to make sure Metro's dedicated funding continues to grow instead of the existing capital contribution. But admittedly, that does start from a slightly, in the context of the Transportation Trust Fund, higher level of 164 million instead of 143 million. Look, MDOT has their usual testimony when it comes to one of my bills, and I don't know if they're planning to testify out loud, or you can read their testimony. And I'm happy to go through any questions about that. But it's frankly not a surprising bit of rhetoric for them. And I look forward to answering any questions and continuing to work with this committee to make sure that one of our state's transit systems continues to be funded at safe and appropriate levels. Thank you, Madam Chair.
Thank you. Any questions? Well, what is the, you referred to their testimony. What do they have to say about your bill?
As always, they love my bills and everything I'm doing on transit, Madam Chair. So I guess we should just move favorable if there are no questions.
Oh, I got it. All right.
Delegate Grice is making a joke, but he's on mute.
I was going to say, I'm just busy checking my blood pressure. I think we're.
Yeah. Well,
Madam Chair, I will say, look, one of the things they raise is that it's not the subject of regional discussions, but, I'll just point out that it is the subject of regional discussions among elected officials and maybe not the bureaucrats in the transportation department. So Senator Feldman and I meet with a group convened by the Council of Governments, regionally discuss these issues around WMATA, including this funding issue.
Very good. I don't know. I think it's kind of an odd day when Delegate Grice and Delegate McIntosh both have to check their blood pressure. Yeah, so let's let that one sit for a while. We do have here to testify for the bill, Brian Weevil from the Amalgamated Transit Union, Local 689. Is Brian here?
Unfortunately, Madam Chair, I have not seen him enter the waiting room.
Okay, well, if he does, let me know. And if
I know they were
not,
double booked on another bill, Madam Chair. So
okay, all right, thank you. But he was here to testify in favor of the bill. You want to move to your next bill?
Certainly, Madam Chair. Thank you. Well, good afternoon again, colleagues. I come before you today with HB 458, which is a collective bargaining bill, revisions and budget bill appropriations. In short, Madam Chair and committee members, this revises our collective bargaining system to shift to a system of binding arbitration. As you all know, right now we have a collective bargaining approach in which, to put it simply, the administration, sometimes it's the higher ed institutions, but usually the governor or the Department of Budget and Management, excuse me, negotiate every year or every few years with our various labor unions. If they do not reach an agreement, the governor is able to impose the solution of his, someday her, liking. There's no requirement that it be based on anything the parties have discussed before that they negotiated over. It's not a mix and match of their offers. It's not a selection of one of their offers. It's whatever the administration decides to do. Over the past few years, this has led to a few years where parties have either, from my perspective, felt pressure to settle early with the governor or have been unable to reach agreement with the governor, and the governor has imposed sometimes differential solutions. And some of my colleagues sometimes wonder why the unions come before the General Assembly. It's because of differential treatment. They see some favored unions by this administration getting 7% raises and them getting a potential bonus if certain BRE numbers come in. So this would put in my mind, a fairer system whereby we could better resolve labor disputes using a neutral third-party arbiter. The bill requires that at the beginning of the negotiation period, both sides will agree on a neutral arbiter by July 15th of each year, with negotiations concluding by September 30th. If an agreement is not reached by that point, an impasse is declared and binding arbitration will be triggered. Each side would be required to present their best and final offer to the arbiter, who's required to make a final determination by December 15th. Binding arbitration will avoid the protracted labor disputes we have seen in recent years by taking some of the politics out of the disputes and giving both sides an incentive to come to mutual and negotiated agreements. There's precedent for binding arbitration in Maryland. 8 counties currently impose binding arbitration for fire and EMS bargaining units through charter or code level legislation. And of course, across the country, there's plenty of states that do binding arbitration, including among some higher education institutions, I believe in California and Illinois. There is a little bit of complexity with the bill because it's a combination constitutional amendment and statute. And that's because when we're sort of requiring the governor to include something in the budget, there's a constitutional issue that's implicated there, so it has to be addressed through the Constitution, but we don't need all the provisions governing the timelines and the selection of the neutral arbiter and all that in the Constitution, so it has an accompanying statutory section as well. And so happy to talk about that if anybody is interested. I think there are a few witnesses here to speak in support of the bill if you're willing to hear them, Madam Chair, prior to the questions, but however you see fit. And I thank you for your consideration.
You're very welcome. I think we have one question for the sponsor, Delegate Kettleman.
Thank you, Madam Chair. This may be addressed in the constitutional amendment. I apologize, I haven't read it, but my concern is turning over decisions like that to a non-elected body. I assume that there are ways that states do it, but it sounds like a really bad idea. Can you make me believe that it isn't?
Sure. Well, I think there's a couple of things I'll say in response. I mean, first of all, I don't think it is the case that it makes sense to just let one elected official who's on one side of the negotiations have the final say. I mean, that's the situation we're in now. It's not as though we're saying, okay, the governor and the bargaining unit are at an impasse. Let's ask the comptroller, or let's ask the legislature, let's ask the treasurer what they think. We're saying the governor right now and a bargaining unit are in an impasse. Okay, let's let the governor decide what to do. So to me, that's not an approach that makes sense. Now, there is a potential safety valve, and it really gets into the weeds of the bill, but that goes to even if the governor is bound by the collective bargaining decision from the neutral arbiter, does that mean the General Assembly has to enact it exactly as it comes into the governor's budget, or could it be subject to like a BRFA type provision? And so that's something that we can potentially discuss as sort of a backstop there if you were truly in an unprecedented or difficult situation.
This whole thing arises out of the fact that public bodies were never intended to be part of the labor union group, because they're dealing with, when they're bargaining for taxpayers' monies. So got a governor who likes to make them happy, or a legislature. They're not on the hook. The taxpayers are. So I guess that's already come and gone, but I guess it still bothers me. But thank you.
Sure. Your memory is longer than mine, but for at least 25 years, we've had public sector bargaining at the state level, as you know.
Well, Roosevelt initially said very clearly when he enacted it to begin with, no, it does not.
Well, Delegate Kettleman, I know your memory is not that long, so I know you weren't at those.
I read. But anyway, thank you.
You're welcome. Okay, we have two people signed up to testify. Let's begin with Lance Kilpatrick. You have 2 minutes.
Thank you, Madam Chair and members of the Appropriations Committee. Good afternoon. For the record, my name is Lance Kilpatrick with AFSCME Council 3. We represent approximately 30,000 state and higher education employees across Maryland. May of this year will mark the 26th anniversary of collective bargaining for Maryland state employees. In the years since Governor Paris Glendenning's executive order, Maryland has continued to improve its collective bargaining practices to have in place processes that are fair, balanced, efficient, and conclusive. This proposal adheres to that path. The concept behind collective bargaining is to establish a forum for management and labor to periodically sit down at the table to discuss issues including equitable compensation, leave and benefits, processes to allow employees input and participation into the decision-making process, and myriad other terms and conditions of employment. The linchpin of collective bargaining is a mutual understanding and respect for the process itself, where finding common ground through deliberation and compromise is acknowledged by all parties. Now, unfortunately, compromise is not always the case, and under present Maryland law, an employer within state collective bargaining can effectively refuse to move from their initial positions and thus create a stalemate that has no resolution. Without incentive to work towards agreement through compromise, there is no concern for the consequences of inaction. And as AFSCME members have testified in the past, there are real life consequences that are happening because of our existing system. House Bill 458 is a strong and positive step toward enhancing fairness, balance, efficiency, and resolution. It follows a model that is well established in other states and among Maryland counties. We thank you and we urge a favorable report of this legislation.
Thank you. David Wright.
Good afternoon. Thank you, Madam Chair, members of the committee. I'm David Wright. I'm an attorney with the law firm of Conn Smith and Collins. I have the benefit of representing AFSCME Maryland Council 3, many IAFFs, AFSCME Council 67, and other unions around the state. I've been practicing and performing arbitration and negotiating for unions for the last 6 years. I've been representing Council 3 for the last dozen years, and my firm has been involved in labor matters and binding arbitration at the county, city, and other levels for the last 30-some years. And we brought to bear our experiences there in working with the sponsors to craft this bill. This is, in fact, 458 is a really sound solution to the troubles that I've seen and the Council 3 has experienced on the front lines dealing with a process that simply doesn't get to a resolution that the parties can believe in. Collective bargaining is about problem solving, and problems that fall on deaf ears and have no rational solution, or where a rational solution is ignored, is frustrating beyond measure. This addresses in process a timeline, a week over week resolution scenario that keeps the parties focused on getting to an agreement, both during their routine negotiations and through mediation, and only if necessary. And in my experience, it's been very rare that it is necessary. Only occasionally do you get to an arbitration hearing where you have a good neutral who's trained in these activities to listen to both sides, listen to the problems they've identified, listen to the solutions they've proposed, and to make a decision from there. As to the accountability, you, the General Assembly, will have the final accountability in determining whether or not a decision is appropriate for funding. The timeline here is appropriate to match the budget process. We're careful to do that. This is from start to finish based on what has worked very well throughout Maryland and in other states. I'm glad and welcome any questions.
Delegate Grist.
Yeah, thank you. And one of the comments that really jumped out at me was a mutual respect to the process, and that's certainly one of the things that I've been questioning for the last, at least since I've been on this committee. But I guess from my perspective, I'm at least looking at a lot of the bills that we've looked at over the past couple of years, and with collective bargaining, it seems like the problems always exist when the labor unions don't get exactly what they want, and that's really at the end of the day, that's where the problem lies. So if we were to move forward with this bill, and we do have this arbitration process in place, is there anything in the bill that would prevent the labor unions from, when they don't get what they want through this new process, which hopefully we can all respect, is there anything that will prevent them from coming to the legislature to get what they want when they don't get it through this new arbitration process?
They will have been satisfactorily heard at that point.
Mr. Wright, why don't I go ahead?
Oh, thank you, Mr.
Sorry.
Delegate.
That's okay with you, Madam Chair.
Fine.
Great. Thank you, Madam Chair. So obviously, Delegate Grice, the bill is always open for amendment and discussion. I mean, we do have to be a little bit careful about circumventing people's ability to petition their government for things, right? I mean, people have the right
No, I agree.
to ask the legislature for things. Doesn't mean we have to do them. And I'll also note that at times, some, although not you necessarily, but some have accused those of us who bring bills that are our ideas of doing it because we were asked to by the unions. And I'll give an example. In my case, I brought a bill on, big shock, transit benefits for union workers, state employees. And I was told by several people that I was doing that to circumvent the collective bargaining process. Collective bargaining process had nothing to do with that bill. In my mind, it was a topic I was interested in and I thought made a lot of sense. So I understand what you're saying, and I've obviously heard it from you before, and maybe there's a way to address the concern, but you can't entirely limit the ability of people who might feel aggrieved by a process or legislators who are participating in the process from coming forward with their ideas for the legislature to consider.
I don't disagree with that. Thank you.
Very good. Thank you very much, Delegate Corman. Are we ready to move on to 379?
think there might be another question, Madam Chair.
Oh, I'm sorry. Delegate Beitzel, I'm very sorry. You have a question?
Yes, of the sponsor.
Yes.
I used to be an administrator of a public agency and did water and sewer works and projects that involved a lot of contracts, and we get into contract negotiations, and in some cases we had binding arbitration. It's my experience in almost every case in binding arbitration that the arbitrator ended up in the end just splitting the sheet, and nobody was really happy, and they split it down the middle, but it usually always ended up costing the government agencies more money for the completion of the projects that we, and in my case, water and sewer projects, that the public had to end up paying more for. And so in this particular bill, if it would pass and you have a governor that won't agree to a certain provision, isn't it likely in the end that the state of Maryland through budgets and the cost in the budgets would end up have to pay more for whatever it is that they're having arbitration on?
So I think there's two types of costs. One is the actual administrative costs, and there is a cost to this system. If your question is, are the employees going to get paid more automatically if you have binding arbitration? I think the answer to that is we don't know. It depends on the results of the arbitration. So, I don't think we know the answer to that, and I think it'll be incumbent upon DBM or the administration, if they're concerned about something that's been put in, to explain to the neutral arbiter why it's not a good idea, why it's unaffordable, or whatever the situation may be. But the system we have now is the governor doesn't really need to explain to anybody why he does or doesn't want to do something, because in the end, he gets to decide under the current system. Oftentimes, the parties come to an agreement, partly because they know they're at the mercy of the administration in the end, but not always. I think there's a better way to do it.
Thank you, Madam Chair.
You're welcome. We do have some folks signed up to give testimony, oral testimony, unfavorable. Is Erica Snipes here? State Labor Relations Board?
Yes, Madam Chair, member of the committee.
Okay, would you go ahead?
Yes, ma'am. Thank you. Thank you, Madam Chair, members of the committee. My name is Erica Snipes, and I serve as the Shared Executive Director of Maryland's 3 labor relations boards. I am joined today by 2 of those board chairs, as well as by board's shared counsel, Christopher Franzoni of the Attorney General's office. We have submitted written testimony as well. I am here in my capacity to provide any follow-up information you might need from us today, as well as to answer any technical capacity or operations questions you might have about the boards in general. But I'd certainly like you to hear from our 2 board chairs who are here to speak with you about the substance of their concerns about House Bill 458. Thank you so much.
Thank you. Very good. So we'll move to Harriet Cooperman, please.
Thank you, Madam Chair. Members of the committee, my name is Harriet Cooperman, and I am chair of the State Higher Education Labor Relations Board, and I have been a member of the board since its inception in 2001. I have 3 serious concerns regarding the legislation's creation of the role of an arbitrator to serve in various capacities in connection with the parties' negotiation. First, the board was created to administer and enforce the collective bargaining law and resolve unfair labor practice charges, including negotiation disputes. HB 458, which authorizes a third-party arbitrator to hear negotiation disputes and to issue binding decisions, directly conflicts with the board's jurisdiction to resolve unfair labor practices. Second, and that concerns the standard of review on appeal. The bill provides that the arbitrator's decisions are final and binding. Can an aggrieved party appeal the arbitrator's decision? Critically, under Maryland law, the scope of review of an arbitrator's decision is extremely narrow. A court can overturn an arbitrator's decision only for fraud, arbitrator misconduct or corruption, procedural unfairness, deciding issues beyond the scope of the matter submitted, and blatant mistake of law or fact that's apparent on its face, In contrast, a court can overturn the board's decision if the findings of fact are not supported by the evidence, or the court finds the board's conclusions of law were incorrect. Third, conflict of interest. The legislation assigns 4 distinct roles to the arbitrator: proctor, judge, mediator, baseball or final offer arbitrator. Wearing each of these hats creates an inevitable conflict of interest. A circuit court judge who presides at a pretrial settlement conference will not be the judge at trial. There is information learned during the negotiations, confidences that the parties may divulge to a mediator to settle a dispute, and conduct during each of these phases that would not be admissible evidence at a hearing, but if otherwise known to the arbitrator, could very well inappropriately influence the decision. Those are our 3 concerns. And let me just say one thing with respect to the impasse. We agree that currently there's a void that exists under the statutory scheme once impasse occurs. And the law offers really no effective means to resolve the impasse with final and binding contract terms on the open issues. We would welcome an amendment to the law to provide a means to close this void. However, we do not believe that HB 458 is the answer. Thank you, and I'm available to answer any questions.
Richard Steyer? Is Richard here?
Yes.
I am. I'm just trying to get on. Here I am.
There you are.
Technology. Thank you, Madam Chair and members of the committee. Ms. Cooperman has pretty much laid out the issues that are of concern both to her board and to the SLRB. On the issue of the jurisdiction, I can only try and emphasize that this bill, by appointing arbitrators in every case with the authority to rule broadly on all issues of collective bargaining, including bargaining in good faith, is going to, they are going to be acting on matters that are within the exclusive jurisdiction of the labor boards. I think our decisions are designed to be part of a body of law. We try and apply the law consistently to all cases. And I think that there's a genuine risk that by giving the authority of arbitrators to rule in areas of our jurisdiction, that we're going to result in inconsistent legal interpretations and outcomes between the labor board and the arbitrators, and between the arbitrators themselves. I think that we're going to have a situation where nobody really knows what happens if an arbitrator's ruling conflicts with the state law as interpreted by the labor boards. These are difficult and concerning questions with the framework of the bill to give arbitrators authority over our jurisdiction. And finally, I would say, obviously, this is a bill that's designed to provide an impasse procedure at the end. But it's not necessary to grant arbitrators the authority to issue rulings on the ongoing day-to-day collective bargaining to handle the impasse procedures. The impasse procedures at the end require an arbitrator to make a choice. There are 11 factors which are outlined in the bill. Most of them are economic, none of which have anything to do with the day-to-day bargaining that went on before. So the arbitrator, or whomever it might be at the end, ability to make a decision does not require an intrusion into the jurisdiction of the committee.
Very good.
Thank you very much.
Thank you. Any questions? Okay. Do we have, Christopher, do you want to add anything, or do you feel like it has been covered?
I'm just here as advice for the chair. I have no comment.
Okay, thank you. Thank you.
Thank you.
All right, it looks like that concludes the bill hearing. And we'll now move to House Bill 379. Delegate Corman.
Madam Chair, this one should be significantly easier. House Bill 379 is the Independent Agency Health Insurance Option Act. I served on what the governor called the STAR Commission, chaired by former Appropriations Committee member Andy Serafini over the interim. And one of the things that I learned during that process is we have a few of these quasi-state agencies that are not currently participating in the state's health insurance system. So we worked with them as well as the Department of Budget Management to try to understand that process a little bit better. It's better for them to be in the state health insurance system because it's cheaper, but it doesn't cost the state anything because those quasi-agencies out of their existing revenues and funding streams would need to pay the employer share. That doesn't get shifted to the general fund or anything like that. There is a process that DBM undergoes to determine if a quasi-agency can be added without disrupting the tax status of our state health plan. The bill asks them to do that work in 30 days. They've requested an amendment to 60 days, which if the committee wants to move forward with this, I believe is very reasonable. We've sent a copy of that amendment over to give them 60 days to review whether or not three quasi-state agencies, the Maryland Clean Energy Center, the Maryland Agricultural and Resource-Based Industry Development Corporation, or MARBIDCO, and the Brainbridge Development Corporation should be permitted to opt into the state's health insurance system. So that's what the bill does, and I would ask for a favorable amendment vote, Madam Chair.
Okay, any questions of the sponsor? I see none. We now have two people here to testify in favor. You get a couple of minutes each. We have Steve McHenry, MARBIDCO, and we have Pamela Powers of the Maryland Clean Energy Center. So Steve, why don't we begin with you?
Thank you very much, Madam Chairman and members of the committee. Great to be back before you again this session.
Yeah.
I think this is a pretty straightforward bill. This is bringing MARBIDCO, MCEC, and the Brainbridge Development Corporation into a group of a dozen or so instrumentalities of the state that have the option of participating in the state's health insurance plan. And if we elected to do so, we would pay 100% of the cost for our employees to participate. MARBIDCO today has 9 employees. We have 1 vacancy. So when we're fully staffed, we have 10. We've been around for 15 years now, which is hard to believe. And I want to thank this committee and its chairman for its great leadership in creating MARBIDCO several years ago. We've been fortunate. We haven't really lost any prospective employees because we didn't have a health insurance plan to offer them when they were being hired. We are all fortunate to either have spouses or for our younger employees, they can buy a coverage on the exchange fairly reasonably. We do offer a subsidy to help with the out-of-pocket costs for our employees, but this would really give us another tool in our hiring toolbox to have this option available to our employees. So we certainly would ask for a favorable report of this legislation. Certainly want to thank Delegate Corman for putting the bill in. Thank you.
Thank you. Pamela? Who was it that was signed up here? Pamela Powers. I thought, there you go.
There I am. There it is.
Thank you.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Pamela Powers, and I'm Legislative Affairs and Administrative Manager at the Maryland Clean Energy Center. Thank you for allowing me to testify on behalf of Kathy Magruder, our Executive Director, in support of HB 379, State Employee and Retiree Health and Welfare Benefits Program and eligibility for enrollment and participation. HB 379 allows employees of several quasi-government units of the state to participate in the health insurance benefit options offered by Maryland for its employees. Other instrumentalities of the state are authorized to participate in the health insurance benefit offered to state employees. And we feel it's only fair and equitable that MCEC and the other 2 organizations be included among those eligible. As you know, the current employment market is highly competitive. Access to quality healthcare is one of the main considerations among candidates. In order to attract, hire, and retrain highly qualified candidates to achieve our mission, MCEC must meet the healthcare expectations of those individuals. The Maryland Clean Energy Center does recognize the cost associated with enrolling employees in the system is its sole responsibility, along with the contribution of our employees. Aside from processing agreement documents, there really is no state cost associated with this legislation. We want to take the time to thank Delegate Corman for recognizing the importance of this issue and sponsoring the bill, and request a favorable report on House Bill 379. Thanks so much.
Thank you. Any question of the witnesses? Thank you very much.
Thank you.
Now we're going to move, and thank you, Delegate Corman. Now we're going to move to House Bill 406, Delegate Resnick. Before we begin the bill hearing, let me just say the following. We have several pages of people who've signed up to testify for this bill. This is an issue area that we know intimately on this committee about. In fact, I think it was this committee that brought the issue to the forefront several years ago. So I'm going to ask that Delegate Resnick introduce the bill. And then I'm going to ask everyone who's here, because we have pages of people who are going to, tell us very important things about how this is an important bill, and we agree, okay? So I'm going to ask you all who are signed up favorable and favorable with amendment to make your testimony very short. I'll give you probably about a minute each to summarize your testimony. Delegate Resnick.
Thank you, Madam Chair, members of Appropriations. I do apologize. We've been going on at a pretty steady clip at this point, and we're going to have to slow things down a little bit. But I think the parameters that you are putting in are fair, and we should be able to get it through. So HB 406 is a bill that, as the chair said, we have heard before in mostly the same fashion. This committee actually passed this legislation, and the House passed this legislation back in 2002, sponsored by Delegate Learman at the time. Unfortunately, the day after we passed it and it crossed over to the Senate was when we shut down for COVID and all had to leave. So the bill ended up dying. And we had made a concerted effort to try and work with the department to try and resolve this issue without legislation. Unfortunately, I believe that effort has failed, which is why we are back here again. The main purpose of this bill is to address hospital overstays for children in DHS custody. It specifies that the conditions under which the child can be admitted to either a psychiatric or behavioral health department or a hospital in general, and what's under what specific needs, and requires that the department take timely action when it is no longer medically necessary for that child to be in a hospital setting. The one difference from 2 years ago is that in addition, we have added a reporting requirement to DHS to notify the Office of the Public Defender whenever a child is moved from one placement to another. This will allow the public defender to track where the children are being placed and prevent the department from picking up a child at one hospital during an overstay and simply taking them to another hospital and checking them in there, which is something that we know has occurred over the last few years repeatedly. There is no reason that the department cannot open new group homes, residential treatment facilities, and other treatment centers. Back in 2008, DHS asked me to sponsor legislation giving them more flexibility in issuing group home and residential treatment facility licenses to circumvent the existing certificate of need process when no other placements exist. Since that legislation, at their request, only last year did the department open 4, only to stave off a pending class action lawsuit on behalf of the children in their care. But let me be clear, they didn't open 4 facilities, they opened 4 beds. These children are being dumped in hospitals and emergency departments, being brought in initially for acute care and then left there after it has been determined it is no longer medically necessary for them to stay. Because it is not considered medically necessary, Medicaid also does not reimburse the hospitals and denies the charges. So our hospitals are forced to eat the cost while taking up valuable bed space either in emergency departments or the hospital, especially in this period of COVID and massive hospitals of bed shortages. At present time, at present time, there is currently a child at Johns Hopkins Hospital that has been living there for 6 months. Another child has been living at Shepherd Pratt for over a year. These are children that are sitting in hospitals with minimum staff interaction, no socialization with peers, no schooling, not allowed outside, etc. They are basically, for lack of a better term, prisoners of the system. I am aware of some concerns that have been raised, and some folks are going to be testifying favorable with amendment about those concerns. I think those concerns are fair, and we need to find a way to address them. But we have to understand that these concerns are based on the failure of the department. The concerns stem from, if we do not allow these kids to stay in hospitals, they're going to end up in hotel rooms or sleeping on the floor of a DSS office. And those are legitimate concerns because the department has failed in their responsibility to these kids. If they get moved to a hotel room, the situation, that is an inappropriate situation. But at least in that situation, the department is actually forced to pay the hotel for their stay. They don't get to leave them in hospitals for free. And this administration will then have to take some financial responsibility and fix this problem. I'm also just very quickly want to address, the Attorney General has raised some opposition to this, and I want to address that issue. It appears the AG's office, in my opinion, the AG's office is wrong, and their concerns need to be addressed. These children, for the most part, are not in psychiatric facilities. In fact, we only have 12 juvenile psychiatric beds in the entire state. Another issue this administration has repeatedly failed to address. These children are mostly in regular hospital rooms or emergency department beds. Their mental health issues are varied and unique, and a psychiatric facility is not always the most appropriate course of residence or treatment. Residential treatment facilities are appropriate in some cases, but so are group homes. In some cases, living back home with families and being provided one-on-one care, etc., are all very appropriate approaches that need to be taken based on the individual needs of the children. The problem is the administration has simply not wanted to spend the money to do what is right by these children, and dumping them in a hospital is, at the moment, free. Only legislation or the threat of lawsuits has spurred any action. The goal of this bill is not to take kids out of a hospital setting if it is medically necessary, but rather to help those who don't need to be in a hospital to find better placement, and to keep all stakeholders accountable and aware of the status of these children. Happy to answer any questions and ask the committee for a favorable report on HB 406.
Thank you very much, Delegate Resnick, for presenting the bill. We have a question from Delegate Smith.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill. I mean, this is a really distressing situation that you've outlined, and I just had a couple of quick questions just for my own understanding, because I am new to the conversation, is that I know that this bill would, when passed, would go into effect, I believe, June 1st, right? So my only concern, and I think you spoke to it a bit, but I just want to give you another opportunity to help me out, is that if only 4 beds have been created recently, I'm concerned there may not be sufficient time to ramp up adequate placements. I get your money talk about at least the hotel gets paid, but I don't know if that's optimal for these very vulnerable young people. So I guess I want to know, have you thought about any type of phasing to ensure there's an adequate bed, the bed that they need available? Because I think this bill is so important, and I thank you for bringing it.
Yeah, thank you, Delegate. And I don't disagree that, and I know that is the concern of a lot of the behavioral health community, is where do we put the kids if there are no, placements available for them? And I totally get that. The department has had 4 years to be, and it's interesting because when I first passed that legislation in 2018, it was not related to this situation. It was related to a similar but different situation where we were shipping kids out of state for treatment because we didn't have the right beds. So we were signing MOUs with facilities in other states for upwards of $1 million per year per kid. to be able to get them treatment because we didn't have the facilities here in the state. So that's where we provided the expansion of what was at the time a very restrictive licensing scheme to be able to open these facilities. It's been 4 years. And frankly, I don't know of another way to get the department to do what's right. The other option on the table is the pending lawsuit that the Venable law firm has been itching to file, to be honest. They want to file a class action lawsuit on behalf of these kids. The department has been begging them not to file it, and they have restrained themselves on the promise that more beds will open, and nothing's been done. So at some point we have to force the issue, and I would love to figure out a better way to do it. And I'm open to working with the advocates to make sure we find the right solution.
Next, we'll have a question from Delegate Grice.
Yeah, thank you, Mr. Vice Chair. Yeah, I mean, this is if any issue that comes to our committee, this is one that is as nonpartisan as they come. I mean, not only we're taking up hospital space, but we're also dealing with families in a crisis situation, and there's so much uncertainty in these families where they don't know where their kid's going to go. Much less in a couple hours, but even 4 or 5 days, and in some cases, weeks after. So hopefully we can find a solution to this. But obviously, what the biggest concern that I have, and I hope that we can find, and I'll do whatever I can to help whomever to find this solution, is we do have to find bed space. If I'm not aware of any legislation that we've had in the past that would have mandated that somebody builds bed space throughout the state with a funding source attached to it. I'm not, as you guys know, I'm real careful about spending taxpayer money, especially moving forward in the future with a lot of the financial uncertainty that we have with this state. But that's a priority for me. I would love more than anything to do this at whatever cost is necessary to do this. But that's the issue right now. And my concern moving forward is, are we going to put the cart before the horse? We're going to mandate that department DSS that they take these kids out of these ERs, but there's really no place to put them at this point. Is that still? Is that unintended consequence being addressed in this bill? And I'm not trying, this is not a gotcha question. This is a real question. I want to help you.
No, I understand. And Delegate Grice, I appreciate it. And I fully acknowledge that this bill forces action that could potentially have some unintended consequences. And that's why I'm willing to work with all the parties in this process over the next couple of weeks to see if we can get this bill right. But I do want to point out, 2 years ago, we passed this legislation out of the House. Because it didn't pass, and I would argue it didn't pass because COVID got in the way, frankly, because we shut down. But even though it didn't pass, we passed it out of the House. Our intent as a legislative body was made crystal clear to the department, and they did nothing until the threat of a lawsuit was finally waved over their heads frankly, within the last year. So I am intent on trying to find a solution. What I am desperately trying not to do is give the department one more reason to kick the can down the road. And that's where my concern is.
Have we had any bills in the past where, again, we're going to require the state to build some facilities, to build beds, and then require that spending? The bill that you're referring to didn't do that, I don't think, did it?
It's almost the same bill as this one. So no, it didn't. But, we've never forced them to build beds. What we did do, as I mentioned in 2018, when I passed legislation, was to give them the tools to issue licenses. All of these beds are private. They're not government. They're not government facilities. These are all done through private providers who will provide, group homes, one-on-one care, foster care, therapeutic and residential facilities. These are all private nonprofit providers. So they need a license to be able to open those facilities, a license for 1 bed, license for 10 beds, whatever it may be. And 4 years ago, we passed that legislation to say, if there is no bed available for this person with this unique situation, here is your ability to open a new facility and issue a license. And every time I asked, I think for 2 years, I asked, where are we with the new licenses? Where are we with the new licenses? And the department's response has consistently been, oh, we have an RFP on the street. We have an RFP on the street, but nothing has been done.
Is it because of the private investors? I mean, is it the private side that's not building these things, or is it because of the department that's holding up these private investors from actually doing what they wanted to accomplish?
So it's not a matter of private investment. These nonprofits operate, I don't want to say at cost, but pretty darn close to cost. They will go out, find a home, townhouse, whatever, for a group home. They will staff it appropriately. They will build it out appropriately, and then charge the state based on their license for a whatever the cost is per child per day cost, the way we would do any fee for service function. So it's not a question of investment. It's a question of simply finding the providers who are willing to do the work for the daily rate. And part of the problem has also been the rates have been so low. Again, an issue that the department has refused to address. So the rates have been so low that they don't cover their costs to be able to provide this function.
Okay. I'd like to work with you on this issue. It's something obviously very important.
I appreciate it. Thank you.
Next question is from Delegate McKay.
Thank you. Thank you very much. So is there a defined population that we're talking about? I mean, how many kids are we talking about in the state of Maryland that are in this particular situation, please?
It's not a very large group of kids, to be honest. I believe right now we're somewhere in the 2 to 3 dozen. We've been as high as 50, 60, 70. It is difficult to get an exact number from the department because circumstances are always changing. But we are not talking about a large population of kids. And we're not talking about thousands of kids. We're talking about, a manageable number who have highly acute cases of highly situational cases. The cases either stem from, abuse or, coming out of a home where addiction was particularly it's the kinds of folks that are having behavioral health issues that cannot simply be addressed by putting them in a large group home or a large therapeutic setting. They need specialized care.
And so that's kind of a little bit of what I'm trying to talk about is, we need to do what we can do to help these children, okay? But we also need to not put state employees in a situation that they're going to be unsafe. And I'm just trying to figure out how this bill, while I think it has good intentions, I don't know how it actually is going to fix the problem. It seems to me, so I don't know how it fixes the problem. So is there actual funding, that a dollar amount that would go for this, such 75,000, 100,000 or something like that?
So we have not designated a specific funding amount. Again, each child's case is different. Some require one-on-one care. Some, in many cases, that could be done in their home setting. Sometimes they need to be in a residential treatment facility that specializes in the kinds of cases that these children have. It varies, and I will tell you the cost is significantly cheaper than keeping them in a hotel room. I'm sorry, in a hospital room, if and when the state actually paid the hospitals, which they currently don't. But I will tell you, at the time when we were dealing with the out-of-state placements, these memorandums of understanding with these out-of-state facilities were upwards of $1 million a year a kid. And when I asked the department why can't, and they were, at the time, there were 50 kids out of state, we were paying $50 million a year. And when I asked the department, can't we open group homes or residential treatment facilities for $50 million a year to accommodate these kids, their response is we can't issue new licenses, which is why we fixed the problem. And still nothing had gotten done.
Well, I believe you had mentioned something about that maybe some in-home care could be done. What I've understood back in my neck of the woods is I've talked to a couple of the different social workers that a lot of the times the families don't know what to do. They're just done with the child. I know how sad and hard that is to say, but they just don't know what to do. And there again, I go back to my whole concern of, I know we're trying to address the problem, but I don't know exactly how we're actually solving it without giving a dollar amount to actually create the beds, because that's at the end of the day seems to be is creating the bed. And if it's the family, then we've got to be looking at it as a holistic. So I'll switch gears. On the other part of the bill talks about the task force created and that kind of stuff. How is that different from the children's cabinet that's already created? Is it simultaneously, or is it different?
So the children's cabinet has not been addressing this issue. Again, this is part of the problem that I've had with inaction from the administration. I will say I heap most of the blame on the Department of Human Services for this, because they are the ones that track the kids and they're the ones that have ultimate responsibility. However, there is equal blame to go to the Department of Health, the Department of Juvenile Services, depending on the child's individual situation. And to address your other question, at-home care is possible for a subset of the kids that we are talking about. It is not a solution for everyone, because you're right, in some cases, the family is unable to have the kid, which is why we need a group home or a residential treatment facility or some other setting. But the blame is to go around, even though DHS is ultimately responsible as the ultimate responsible party for these children. But they have not done it. And, we used to have a governor's office on children that got folded into the governor's office of crime control and prevention. Again, this is not an issue that they have been addressing. And the task force is designed to bring parties to the table that may or may not be part of the children's cabinet already, to be able to specifically deal with this particular population of kids.
Mr. Chair, just one last question, if I may, please.
Delegate McKay.
Thank you, sir. So is in the bill, is there like penalties that the department has to pay if they don't remove a child from a particular time?
I did not put a financial penalty in the bill, although one of the things that I have wanted to do, and I think could be a potential amendment here, is to require, if we don't move the route to the route of they have to come out of the hospital when there's no longer a medical need, then we should at least impose payment to the hospitals for the care of these kids. And when you start paying a hospital rates, suddenly the money becomes, loosens up significantly to be able to provide appropriate residential treatment facilities. So that might be a short-term solution that could address some of the concerns of the behavioral health community, that they are not immediately removed from the hospitals, but at least the hospitals have to get paid for the service of having somebody in those beds. But that is something that we can discuss.
So I'm not necessarily advocating to penalize the department for that, because I'm not exactly sure that the cost of the hospital versus a risky home and sending these children into that is the right thing to do. But I do know that it just seems to me, going back to my original question about the funding, and it just seemed to me, if there was a dollar amount that was set that said, we're going to give you X amount for however many children. And, I understand that at a point in time, we were talking about there was 10 children in the hospital. So to me, out of the 4,500 clients, that population, we can find a place that has 25 beds within the state of Maryland, give them the funding, have the resources there so that it can be taken care of. So it may be an option. So, but thank you for bringing the bill. It is important. I'm just not exactly sure it's the right way, but thank you very much. Thank you, Mr. Chair.
Delegate Young is recognized.
Thank you, Mr. Chairman, and thank you, Delegate, for bringing the bill. When as the chair of the HSS subcommittee, you've been dealing with this and with the department, and as a member, I appreciate the attention you brought to it over the years. I bring that up to say that I don't want to get off the scope of the bill, but this is indicative of a lack of resource, a lack of bed, a lack of space and talent to provide the services that we expect from our departments to meet the needs of not just kids, but also folks, regular citizens that are going through the system. And that's correct, right?
Yeah, it is correct. And, you know, it's, and thank you for backing up your chair. It's good delegate there. Look, the money is in the budget. The DHS has one of the largest budgets of any department in the state behind, you know, health and transportation. The DHS budget is in the billions, right? We have the money, and they have the money to be able to pay all of the current providers for all of the different beds in the various group homes. We are missing, you know, that much, but it is an important that much because it is a highly acute population of kids who cannot just be in any old group home or any other for a residential treatment facility. They need specialized care. And so that money is there. We just have to force them to spend it.
A follow-up, Mr. Chairman.
Delegate Young.
When you were mentioning about how we've had to spend in contract with other states, $1 million for one student, one child. What facilities are they going to? Are they going to a public facility or a state or a private?
No, they're going to private, you know, usually nonprofit facilities in other states. I will convey a brief story about how this issue in other states came up. We had gotten a report that one particular Maryland child was being housed in a facility in Massachusetts that was still using as a form of therapy electroshock treatment. Now, they were not using it on our kid, but they were still using it. And when that came to our attention, one, we wanted to get the kid out of that facility, but second, we wanted to figure out why our kids were in out-of-state facilities in the first place. And that's how the ball got rolling on figuring out that the state really isn't doing right by our most vulnerable kids.
Appreciate the bill and appreciate the time. Thank you, Mr. Chairman.
Delegate Forbes recognized.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. I first read about this in the Baltimore Sun in 2019, and I appreciate that you are continuing to push it and make it an issue. These are, as you said, our most vulnerable children and our children with the highest needs, and so we need to be a voice for them. And so I so appreciate you bringing this bill. Is there a model from another state that we could follow to solve this problem?
You know, that's a good question. I don't know the answer to that, but it's something I will happily explore. You know, these situations, as I said, are highly unique. And so maybe that's my shortcoming in not having, you know, explored other opportunities in other states to see how they do it there. But it's something I will look at and talk to the advocates and talk to folks who are smarter about this than I am.
Thank you. And I'm willing to work with you on it to get this done. So thank you.
Delegate Beitzel is recognized.
Yeah, thank you, Mr. Chairman. Delegate Resnick, I just wonder, here in the state of Maryland, we've been closing juvenile detention facilities, in particular here in Garrett County, we've closed a couple. Are any of these kids that you're talking about or dealing with, are they people, kids that were in juvenile detention facilities and they were turned out and put in a group home or in a family situation where the people that received them are no longer able to deal with them? And would we be better served if they are number one, our question is, are they problem children? And if they are they in trouble or something, would we be better served to have them in a juvenile detention facility rather than spread them around in the community where the people that are caring for them can't handle the situation.
Delegate Beitzel, I think we need to be, so the answer to your question is no. These kids are not from a juvenile facility, but I think it's also very important to distinguish people who have committed crimes and have been sentenced to a criminal facility versus people who are suffering from behavioral health issues such as mental health or addiction. Those are two very different things. And I think to be fair, I think it's very dangerous to equate the two because they are not the same. They are not the same kids.
Okay, thank you, Delegate. Thank you, Mr. Chairman.
Delegate Grice.
Thank you, Mr. Chairman. I just want to add, if I may, that's a very, very important distinction. Oftentimes, these are the kids that we're talking about. Most of the time they're facing depression. They're either a threat to themselves or they may be a threat to someone else. And most often they have never committed a crime in their lives. And in many cases they won't, but they could hurt themselves. And that's the reason why they're under constant supervision in an emergency room. And usually in a room, and I've talked to our local hospitals about this when I was on Delegate Resnick's subcommittee. They clear these rooms out. I mean, this is not an appropriate place for these kids at all. They just need treatment like any other, whether it's a physical treatment or mental health treatment. They just need to be helped. And an emergency room is not the place for that help at all. And like I said, most of these kids, that they have no intention of committing any crimes whatsoever.
Are there any other questions from members of the Appropriations Committee for the bill sponsor? This time we have testimony from 9 witnesses who are providing favorable testimony to all the witnesses. If you could please state your testimony in 1 minute, and there's a timer. First, we have Lauren Fitzpatrick with the Luminous Health Anne Arundel Medical Center. Lauren Fitzpatrick with Luminous Health Anne Arundel Medical Center.
Mr. Chairman, if I may, if we can start with the hospital association and they can kick it off to the individual facilities, I think that's probably the better way to approach this.
Sure, thank you very much. So from the hospital association, whoever's from the hospital association. you kick it
Hi,
off.
Mr. Vice Chair, Erin Dorian, Vice President of Policy for the Maryland Hospital Association. Before you start my timer, after I'm done, would you like me to tick through our witnesses?
Sure, that would be helpful. Yep.
Okay,
1 minute, please.
Thank you so much. And thank you, Mr. Vice Chair and Delegate Resnick, for your continued attention to the challenges faced by our foster youth. I don't want to take up too much of your time because I want to make sure that you hear from our members and their experiences on the front lines. I just want to say that issues of finding appropriate placement for youth in care is not confined to one area of the state, nor is it more difficult for a child who needs next level of care coming from an emergency department versus a child with an inpatient stay. While we completely support the intention of this bill to improve care for these children, we did outline a few areas where we recommend some changes to the legislative text, and we know that Delegate Resnick is willing to work with us, and we look forward to working with stakeholders as the bill moves through the legislative process. These youth deserve a commitment from all of us, including the state, hospitals, and advocates, to work together to address issues creating barriers to accessing the care they need to live happy and fulfilled lives. With that, I'm going to start turning it over to frontline staff who deal with these kids every day. So I'm going to start with Dr. Lauren Fitzpatrick from Luminous Health.
Good afternoon. I'm Dr. Lauren Fitzpatrick. I'm the medical director of the combined unit. Thank you for the opportunity to just speak in support of this bill. I'm going to just get to the point. I had a 17-year-old female who spent 6 months in an inpatient facility who ended up with us because we were her home jurisdiction. She was in DSS custody. She spent 28 days with us in a locked unit. She didn't see sun. She had 4.
Okay, we'll get back to Dr. Fitzpatrick if anyone else wants to go next.
I'm sure. Sorry, Mr. Chair. I know we're having some technical difficulties over here.
We'll get back to behavior became aggressive. She ends up in restraints. It is a downward spiral. It's not fair. It's not.
Okay, I think we're having problems with Dr. Fitzpatrick, so let's go to the next witness.
Sure. Danielle Nichols from GBMC.
Hi, good afternoon. So I just wanted to provide an example of a child that we had here at GBMC. She was brought here for mental health reasons, and she was in foster care at the time she was brought here. Her group home discharged her to the hospital. So when she was ready for discharge, when she had stabilized, she was unable to go back to her placement. And then it took the DSS and then DHS, because it ended up needing to be an out-of-home placement, 44 days after she was medically and psychiatrically stable and ready for discharge in order to get her placed into a placement in Virginia. And this placement had been found and approved at the very initial level at the day that she was psychiatrically and medically stable. So it took 44 days past that point for it to be approved through all the different levels of the system.
Thank you very much, Ms. Nichols. Dr. Fitzpatrick, if you're back on, if you could just summarize in a few seconds.
Oh, I apologize. I didn't realize it wasn't heard.
That's okay. If you could just summarize in a few seconds here.
Yeah, I just think that these children deserve better than physical restraints, 4 walls, and failed attempts at getting them places. And I appreciate you all supporting this bill.
Thank you very much, Dr. Fitzpatrick. Which to the Anne Arundel Medical Center. Next.
Rachel Boro Hernandez from the Johns Hopkins Hospital.
Hello, Chair and members of the committee. My name is Rachel Boro Hernandez. I'm the Director of Pediatric Social Work here at Johns Hopkins Hospital. I support House Bill 406 for the progress it makes in addressing this longstanding issue through 2 key components. The first being that it requires local departments to take responsibility of those in their care. And the second is that it helps to solve the long-term issue by looking at out-of-home placements through a task force. As a hospital, we are responsible to attend the acute healthcare needs of patients. We are not a long-term provider. We are not a school. We are not staff licensed or credentialed to deliver the ongoing services that these children need on a daily basis. But the reality is, due to lack of community-based care, these children get brought to the hospital and remain stuck for days, sometimes months. I want to give you a small glimpse of what life is like for them. Many times they have just been involved in a traumatic situation and abandoned by their parents. They are placed in a small room that is 10 by 8 for upwards of 30 days, up to 6 months or longer, without access to things that may comfort them from home.
Thank you very much. Summarize. Thank you very much. Please summarize it.
So the bill would require local departments to take responsibility for the children and think outside the box to create solutions that better address the needs of these children. They currently do their best, but do not have access to the resources these children need.
Thank you very much.
Megan Perlman from the University of Maryland Medical Center.
Good afternoon, Madam Chair and committee members. My name is Megan Perlman. I'm the clinical social work team lead at the University of Maryland Medical Center for the inpatient psychiatric units. I want to first thank you for allowing me this opportunity to provide support for this legislation on the behalf of the University of Maryland Medical System. Our child and adolescent inpatient psychiatric unit provides care for hundreds of kids each year who require acute psychiatric stabilization. The average length of stay is between 5 and 7 days. Now, I can share a lot of statistics with you, but one piece of data that underscores the plight of children on our unit who are in the custody of DSS is this. Over the past 8 months, a total of 5 patients, or kids rather, in DSS custody spent a total of 250 days in the hospital beyond what was deemed medically necessary and against their will. During this time of unnecessary overstay, these kids miss out on milestones such as attending their friends' birthday parties or even celebrating their own, taking their driver's license test, attending school, after-school activities, celebrating holidays.
Thank you very much, Ms. Perlman. If you could please summarize it.
Support this bill.
Great. Thank you very much, Ms. Perlman. Next.
Mr. Vice Chair, lastly, we have Summer Farouk.
Good afternoon, Mr. Chair and members of the committee. My name is Summer Farouk, and I'm a licensed social worker on the inpatient child and adolescent psychiatric unit at the University of Maryland Medical Center. I want to share with you the human experience of these children. I recently cared for a child with a history of significant trauma who had been removed from her parents' care at a very young age. After 3 weeks on our unit, she was medically ready for discharge. However, she spent the next 80 days waiting for local DSS to find her a home. During those 80 days, she spent her first semester of high school and holidays away from the comforts of simply being a kid. She would often express feelings of blame and rejection, feeling like she was losing herself, which is a reality for all of these kids. What is already a very traumatic experience in their young lives is exacerbated by the inability of local DSS to find suitable placement. With little to no feedback from local DSS, our hospital team began to reach out to these agencies directly. And with careful follow-up, we were able to facilitate an interview. Thank you. And she was discharged the next day. This bill will provide accountability and supports which are desperately needed for these kids.
Thank you, Ms. Farouk. Are there any other witnesses on your list, Ms. Dorian?
Nope, that's it from the hospital field. Mr. Vice Chair, would be happy to take questions or wait until the end.
Okay, are there any questions for the witnesses for the medical and hospital? Okay, next we'll hear from Sanjeev Varghese with the Maryland Office of the Public Defender.
Thank you. Good afternoon, Chair and members of the committee. HB 406 protects the constitutional rights of vulnerable children. It incentivizes DSS to follow current state and federal law for placing those children and not abandoning them in the hospital. It also ensures that the legal representation for all children in the hospital and inpatient units when they are at those facilities past the point of medical necessity. True, HB 406 does not solve the problems of these children not being afforded access to care outside of the hospital and placements, but it incentivizes the DSS to actually follow through with what they are legally required to do by giving them that $2,000 a day penalty if they do not place the child in the community, if past the point of medical necessity. The Supreme Court in several cases has ruled that these children, individuals, are afforded the rights to due process before being committed. This is a way around those due process rights by warehousing them in the ED. We aren't given notification when they're in the ED if they've been brought in as a voluntary or not certified. A DSS can leave the child in the ED, not certify them, and then.
Thank you
Thank
very much.
Thank you,
Appreciate
Chair.
it. Yeah. Next, we'll have Mitchell Mervis from Venable LLP.
Thank you. Thank you, Mr. Chair and members of the committee. My name is Mitchell Mervis. I'm an attorney at the Venable Law Firm. I represent the class of Baltimore City foster children, approximately 1,850 children in the federal class action, LJ versus Masenga. I won't talk about the problem. You all understand it. I won't talk about the legislation. Delegate Resnick has explained it very well. I will talk about solutions and why we haven't filed suit yet, which we were going to do a year ago, had a complaint ready to go. We were told by the state that MDH had approved a new program of $5 million a year for approximately 25 new residential treatment center beds, and that with existing funds, the Department of Health and Department of Human Services would be creating approximately 45 new beds, some psychiatric respite and some group homes. That did not turn out. They are still working on it, and we've been given news that this summer.
Thank you, Mr. Mervis. Thank you very much for your testimony. Next, we'll hear from Amy Petbosic with the Maryland Legal Aid.
Good afternoon. Thank you for the opportunity. I'm the Deputy Chief Counsel at Legal Aid, and we represent foster children across the state. And while we've heard accurate representations all throughout this bill testimony, let me tell you that our lawyers, including myself, have these youth call us every day asking, can we please get off this unit? The problem has been exacerbated during COVID. There are less treatment foster homes, less group homes available now. At least when we represent children who are living in motels, they can go to school. They can see their friends. They can see their family and participate in a softball game. In a hospital with 4 walls, they can do none of those things, and they're given the clear message, you're not wanted. The state has no place for you. It's not okay. It has been attempted to be addressed for years, and the time has to end. There cannot be additional task force without movement towards the solution. It's not appropriate to increase these children's level of trauma by putting them in a place that is not appropriate, is not medically necessary, and is simply a holding cell. Hospitals are not homes. Thank you for your time.
Thank you for your time. Appreciate it. Next, we have Lindsay Balo with the Maryland Office of Public Defender.
Hi, yeah, my name is Lindsay Baylog. I'm a social worker with OPD, the Mental Health Division. I'm going to talk about exactly why it's so harmful for kids to remain hospitalized longer than necessary. So critical development takes place during childhood, but the purpose of a hospital stay is to allow a kid to stabilize from an acute psychiatric episode, one so severe that the child cannot move forward in their development. Even the best psychiatric hospitals don't provide the kind of caregiving required that helps children become functional adults. It probably seems obvious to assume that a hospital would be a safe place for a child, but decades of research actually shows otherwise. Children who are deemed violent or aggressive, as you might guess, this is common for kids who require inpatient care, and kids who witness it, who are in the hospital who witness it. This is incredibly damaging. Hospital environment is not conducive to reducing aggressive behavior, and research shows that conditions in hospitals actually increase aggressive behavior. As others stated, the care is dehumanizing. Research shows that the longer a child stays in the hospital, the more they identify with negative beliefs about themselves and their abilities. Perhaps most alarming, the longer a child is hospitalized, the more likely they are to be readmitted after they finally leave. So no child should have to endure this. I recognize this bill does not offer a solution to the lack of placements. Rather, it protects kids from solutions that are harmful to their mental health.
Thank you very much, Ms. Baylor, for your testimony. Next, we'll hear from Danielle Nichols with Greater Baltimore Medical Center. We already heard testimony from her. Okay, I think it went out of order a little bit. Okay, next, we have favorable with amendments testimonies. First, Kevin Keegan with Catholic Charities.
Thank you, Mr. Chair, members of the committee. I appreciate you allowing me to testify on House Bill 406 with amendments. I'm the director of Catholic Charities Family Services Division, and we work very closely with many of the state agencies that are involved in foster care and behavioral health services, and working with the most vulnerable children in Maryland. There are not new issues on the table here. 20 years ago, there was a lawsuit about kids stuck in hospitals. We've had headlines in the paper about sleeping in DSS offices and hotels. The state needs to stretch. The reality is we know what needs to be done. To Delegate Gross's point earlier, it is not political. In 2008, under the Democratic administration, the Children's Cabinet published an interagency strategic plan. It was very well done. In 2020, the Republican administration published a very similar strategic plan. Both offer significant similarities around the development of evidence-based, community-based services, in addition to addressing the need for high-end services. I believe that the best outcome of this bill will be to develop a mechanism to hold the Children's Cabinet accountable for implementing that plan.
Okay, thank you, Mr. Keegan. Next, we'll hear from Megan Berger with Disability Rights Maryland.
Good afternoon. I'm an attorney with Disability Rights Maryland, the state's designated protection and advocacy agency, which is federally mandated to advance the civil rights of people with disabilities. We regularly advocate for children in the care and custody with emotional and behavioral disabilities who stay in clinical settings long past their recommended discharge. In addition to violating the Americans with Disabilities Act and federal special education laws, extending clinical stays beyond their medical necessity harms children and can exacerbate existing disabilities. As everybody's talked about today, the true root of the grave hospital overstay problem will not fully be remedied until new community placements, preferably therapeutic foster care or small community group homes, are developed and funded, as well as preventive and wraparound services to prevent crises and psychiatric hospitalizations whenever possible. We therefore support the bill with a friendly amendment directing the funds from the Foster Children Support Fund created by this bill to be used for a range of placements and supplementary services, including therapeutic foster care, provision of one-to-one aids for children, and other additional services that will enable children and youth to return to or remain in the community. Thank you.
Great, thank you very much. Next, we'll hear from Mary Beth DiMartino with the National Association of Social Workers Maryland chapter.
Unfortunately, Mr. Chair, I've not seen her enter the waiting room.
Thank you very much, Ms. Wareheim. Next, we'll hear testimony from Judith Chagrin with the National Association of Social Workers Maryland chapter.
Yes. Hello. Good afternoon, Mr. Chairman, Madam Chairman, members of the committee. I'm Judith Chagrin. I'm a licensed clinical social worker with decades of experience in child welfare. I am intimately acquainted from this issue from my years in the trenches. Thank you for reading our written testimony. We believe 406 doesn't go far enough in demanding immediate action for Maryland's child serving agency. As a reminder, Maryland Department of Health is responsible for licensing programs to serve these children, not DHS. As far as hoteling a child with compulsive self-injurious behavior, swallowing light bulbs, bolts, feces, rocks, is dangerous, as is hoteling a child with self-injurious behaviors or sexually provocative behaviors, such as the behaviors of children in the hospital. The real solution, we want immediate relief, 20 psychiatric beds. There are empty residential treatment centers ready to be staffed up, supporting Behavioral Health Modernization Act, and a work group or task force needs to act with a sense of urgency and include those who are experts
Thank you, Ms.
in actually doing the work, the Department of Social Workers. Thank you.
Thank you very much. Next, we'll hear from Evelyn Burton with the Schizophrenia and Psychosis Action Alliance.
Good afternoon. I'm Evelyn Burton, the Advocacy Chair for Schizophrenia and Psychosis Action Alliance. We support the goals of HB 406 and especially the fines to incentivize the administration to provide services. It worked very well with increasing state psychiatric beds for forensic inmates. However, certain provisions we feel will create substantial barriers to emergency and hospital treatment. A judge is prevented from basing a psychiatric hospital commitment decision on all of the pertinent information, and also if an ALJ previously denied commitment. Because Maryland's danger standard for involuntary commitment is undefined, the interpretation varies widely among ALJs and sometimes results in inappropriate discharge. Also, prohibiting a mental health professional from taking a child to an emergency room when in their clinical judgment at the moment it is appropriate creates a real risk to the child and others. Finally, the restrictions placed on hospital emergency room staff ask them to ignore federal EMTALA law, which the Maryland Attorney General's office has previously written takes precedent over conflicting state law. Please see my written testimony for detailed amendments we suggest. Thank you.
Thank you very much, Ms. Burton. Thank you to everyone who provided testimony today. Are there any other witnesses that we may have missed? Seeing none, are there any questions from members of the Appropriations Committee for the witnesses? Seeing none, that ends the bill hearing for House Bill 406. The committee will now move to House Bill 511, presented by Delegate Barnes. It's the University of Maryland Institute for Public Leadership Establishment. Delegate Barnes, please proceed when you're ready.
Thank you, Mr. Chairman. This bill establishes the Institute of Public Leadership at the University of Maryland. I believe it'll create a diverse pipeline of skilled leaders in the state, providing students access with internships, professional development programs, mentorship in the field of public leadership, thereby really creating a professional network for aspiring leaders in our communities and across the state. As you can imagine, Mr. Chairman, I did not come up with this idea or the structure on my own. And we do have the Dean of the School of Public Policy with us, Robert Orr, as well as Nina Harris, the Associate Dean, who can really walk you through the details of how this institute will work and give you some overview of why we believe it's necessary and the real value it can provide our state. So I will defer to them on any technical questions. And with that, thank you, Mr. Chairman.
Thank you very much, Delegate Barnes, for presenting this bill. We'll start with Dean Orr. If you could provide testimony, limit to your testimony to a minute, and then move on to the rest of the witnesses. Dean Orr.
Good afternoon. Thank you for this opportunity, Mr. Chairman and members of the committee. My name is Robert Orr, and I am the Dean of the University of Maryland School of Public Policy. As Dean and as a public servant for many years, I am proud of the top quality public service education we provide and the distinguished public leaders we produce every year, while at the same time, I am humbled by the overwhelming need and demand for public leadership education that far outstrip our current capacities. Your support of the Maryland Institute for Public Leadership is both timely and consequential. The Institute will strengthen the pathway into public leadership as an accessible opportunity worthy of pursuit by our best and brightest from all backgrounds and all walks of life in the state. As effective public leadership education relies on robust hands-on learning, including bringing students to Annapolis and bringing practitioners to students, the infrastructure of an institute will be critical to scaling opportunities to meet the demand. The Institute for Public Leadership will enhance our ability to expand the pipeline of diverse, effective public leaders to serve the state both locally and nationally. We
Thank
are
you, Dean Foley. And thank you,
consideration,
Dean.
and we urge a favorable report. Thank you.
Thank you very much, Dean Orr. Really appreciate your comments. Next, we'll hear from Mark Conway. Mark Conway. Miss Nina Harris, University of Maryland College Park.
Yes, I'm here. Good afternoon, Madam Chairwoman and members of the committee. Thank you for this opportunity to testify before you. For 30 plus years, I've taught numerous leadership courses and have developed and delivered several leadership programs for undergraduates, graduate students, and public officials. An Institute for Public Leadership serving both current and future leaders in Maryland would build upon the long history of similar work in the school. I would like to add that we are uniquely qualified and positioned to launch this Institute for Public Leadership at the University of Maryland. Our experience in developing and offering top-notch leadership programs and courses spans decades and began in 1987 with the Center for Political Leadership and Participation, an institute with the primary focus of developing young people, people of color, women, community leaders, and political leaders. Because of our demonstrated interest and demand in leadership programs, in 2006, we launched the Rawlings Public Leadership Center as a living legacy to Delegate Howard Peters Rawlings. The center's mission was to foster public leadership in Maryland with a special attention on those historically underrepresented in public life. Public leaders were selected from a pool of distinguished elected, appointed, business, and nonprofit leaders in Maryland, many of whom you all know and have had the pleasure of working with. An Institute for Public Leadership at the University of Maryland School of Public Policy would allow us to build upon a long, strong history of developing leaders who are committed to making a difference in Prince George's County, Annapolis, and the state. I'm both proud and humbled to testify before you today and respectfully request a favorable report. Thank you.
Thank you very much, Ms. Harris. And do we have Mr. Mark Conway? Mr. Mark Conway. Okay, at
I
this
see that
time.
he is in the room. We may want to give him just a moment.
Okay, sure. Mr. Mark Conway.
Strong history of developing leaders.
Mark Conway. Mr. Conway.
Hello.
Hello.
Yes.
Mr. Conway. We'll hear testimony from you. If you could keep it to 1 minute, please.
Sure. Let me get my video going. How's it going? My name is Mark Conway. I'm a councilman in Baltimore City. I also serve as the executive vice president of the Chesapeake Conservancy. I am a product of these leadership programs out of University of Maryland. I participated in a number of the leadership programs there, including the Rawlings Undergraduate Leadership Fellows, the Public Leadership Program. I went to the policy school, and I can tell you how much the program meant to me and my success. I didn't know that I would take on a leadership role, especially here in Baltimore City. And I can really attest to how much the mentorship, the insight, and the opportunity to work with colleagues with a similar mind meant toward my eventual success and my eventual drive toward running for office. I can probably attest to, since we all are office sharers, how important it is to have insight in public service and thinking about leadership problems, questions, concerns. I've done it on the nonprofit side, but then also on the public sector side.
Thank you very much, Councilman Conway. Very much appreciated it. Thank you for your testimony and for sharing your personal story. At this time, are there any questions from members of the Appropriations Committee for the bill sponsor or the witnesses? Delegate Jared Sullivan is recognized.
Thank you, Mr. Chair. I just wanted to welcome Dean Orr, who's a District 18 constituent. Appreciate your service, and Delegate Barnes, thank you so much for bringing this bill forward.
Thank you, Delegate Solomon, for the warm welcome. Are there any other questions for members of the Appropriations Committee for this bill? Seeing none, that concludes the bill hearing for House Bill 511. Next, the committee will move on to House Bill 751, which will be presented by Delegate Foley, State Personnel Collective Bargaining, Appropriations Committee. This is the first time Delegate Foley's been joining us today and this during her term. So let's give her a warm welcome when we can.
Thank you so much, Mr. Vice Chair, and honorable members of this committee. I'm Delegate Linda Foley, and I am presenting HB 751, State Personnel Collective Bargaining, which would provide the opportunity to graduate assistants at University System of Maryland Schools, Morgan State University, and St. Mary's College of Maryland the opportunity to unionize and have access to collective bargaining rights. You all remember that last year, the Maryland General Assembly passed legislation to enable employees, faculty, and staff at community colleges throughout the state to organize into unions. So for more than 20 years, the graduate assistants have been advocating for that same right to bargain over their wages, hours, and working conditions. Instead of that, these employees have been referred to a non-enforceable meet and confer process, which does little to ensure that the work issues are addressed. The meet and confer process does not work. In the Senate hearing on a cross-filed bill in this area, Senator Benjamin Kramer pointed out that the meet and confer process does not require any resolution by university administration other than to listen to the graduate students. And during the COVID-19 pandemic, for example, the University of Maryland at College Park didn't even hold a single meet and confer meeting in 2020. Representatives of the University of Maryland have argued in the Senate hearing that the graduate assistants are not candidates for collective bargaining because they only work 20 hours per week. That actually isn't true. Most of them work more than 20 hours a week. In 2016, for example, a study showed that the average number of hours worked was 23 per week, and 1 year later, it was 27 per week. However, the number of hours worked, notwithstanding, any employee who works, no matter if it's 20 hours or 40 hours a week, has the right to collective bargaining. Another argument made by the university administration is that collective bargaining will hurt the mentor-mentee relationship between the graduate assistants and their supervising advisors. This also isn't true. A 2013 study published in the Industrial and Labor Relations Review showed that unionization actually has no impact, or in some cases, a very positive impact on the faculty-student mentoring. From my own long history as a labor union leader, I speak from personal experience that collective bargaining creates an efficient and formal process to address problems and issues within the workplace and takes them out of the mentor-mentee relationship. These arguments distract from the main point of the bill, which is this: these employees have the right to collectively bargain just as their peer staff does in the University of Maryland system. The pandemic demonstrated the need for them to have this right, because when other employees groups in the university system were able to bargain for COVID-related protective equipment and working conditions, graduate assistants could not, and their workplace was less safe. The University System of Maryland and these institutions are fearful and not fearless like a terrapin should be. And it's time that we stop just talking the talk and now walk the walk for graduate assistants at Morgan State University, St. Mary's College of Maryland, and the University Systems of Maryland schools. I join with the more than 1,200 students and graduate assistants who signed the petition, and more than 200 students, faculty, and union members who are testifying here, who are urging a favorable report on HB 751. Thank you very much for your consideration and for listening to me.
Thank you very much, Delegate Foley, for presenting your first bill. And I believe we have several questions from members of the Appropriations Committee. If we could all raise our hands. Okay, all right. We got a lot of questions.
Yeah.
So it's part of our initiation process in the committee, but we do appreciate you.
Thank you. I've been through that in my own committee. So thank you very much, Mr. Vice Chair and members of the committee.
You got it. Okay. Okay. Well, great. Well, so today we have 7 witnesses who are providing favorable testimony. And for real, if we have any questions for the favorable testimonies after we hear them, then we'll take questions. Okay, first we have Simon Sheaf with Fearless Student Employees. And if everyone could limit their testimony to 1 minute, please.
Good afternoon. My name is Simon Sheaf. I'm the Vice President of Government Relations for Fearless Student Employees and a PhD student in the Department of Government and Politics at the University of Maryland. I'll spend my time answering some of the most common arguments the university system makes. I, of course, won't have time to respond to all of them, but I hope you'll read the more than 200 testimonies that have been submitted that answer these questions. I'll point out that the university system makes the same arguments every year without once addressing our responses to them. I think it's a microcosm for how the university administration treats its graduate employees. Yes, it gives us the opportunity to raise issues, but are they listening? I don't believe so, and it appears that more than 1,200 graduate employees agree with me. The university system says policies exist to protect graduate students. I am here to tell you we do not feel protected. And those who are supposed to be protected against tell you we are safe, while those who are supposed to be protected say we are not. I think it's clear whom you should believe. The university system wants to scare you. We ask you to be fearless and favorably report on this bill.
Thank you very much. Appreciate your testimony. Next, we'll hear testimony from Karen Rosenblatt, University of Maryland Chapter, American Association of University Professors.
Thank you for listening to my testimony. I am a professor of history in addition to being vice president of the AAUP. I want to make a couple of arguments today. The first is that our students are poor, even with the raises that they have recently had. They do not have enough money to live on. This means they have to take outside jobs, and this takes time away from their studies. It makes their studies longer. This detracts from the reputation of our university. It is difficult for us to recruit students often because our graduate stipends and our working are so low and the working conditions are so poor. As a graduate student, I was part of my union, and I can tell you that it promoted harmonious relationships. Everyone knew what the rules were because the union helped to lay down the law. Finally, I want to address an argument you're going to hear from the graduate dean, Steve Fetter. He is going to tell you that graduate students are working towards their own dissertation as graduate assistants. This is false. Of all the graduate assistants at our university, 1,200 are working as research assistants, while almost 3,000 are working as teaching assistants. His argument does not comply with his own statistics. Thank you very much, everyone.
Thank you very much for your testimony. Next, we'll hear from Gregory Cremita with the Fearless Student Employees.
Thank you, members of the committee. I'm the current president of the organization and also a computer science PhD candidate at the University of Maryland, and also a longtime Maryland resident, taxpayer, and active voter. Graduate workers hold bachelor's and often master's degrees, and they perform highly qualified labor. Across the USM, they comprise about 1% of the state's population. The administration uses words like student and assistant in order to downplay the value of our labor, and moreover, stoops down to outright lies, such as graduate workers are not paid for their work, or graduate workers are not hired for their qualifications. They're often trying to carve up the graduate workers' rights into categories, saying something like research assistants somehow are less qualified for collective bargaining rights because they're somehow less worthy of benefiting from the research grants that they're supported by if their research also happens to help them obtain their degrees. In fact, many schools don't make such distinctions, including some state schools and virtually all private schools.
Thank you very much for your testimony.
Thank you.
Next, we'll hear from Mr. Todd Reynolds with AFT Maryland.
Good afternoon, Vice Chair Chang, members of the House Appropriations Committee. My name is Todd Reynolds. I'm the political coordinator for the American Federation of Teachers in Maryland. And on behalf of AFT Maryland, we ask for a favorable report for HB 751. I believe you have our written testimony, but I'm here testifying orally to potentially answer any questions you guys might have, because I used to be a unionized graduate teaching and research assistant from 2000 until 2007. I was a graduate assistant, and I want to emphasize both as a teaching and a research assistant at the University of Florida, where graduate teaching and research assistants have been unionized since 1980. From 2003 until 2005, I was president of the Grad Labor Union at Florida. And from 2004 until 2007, I was the union's bargaining chair in labor negotiations. It's important to realize in your deliberations on this bill that graduate assistants exist as both students earning a degree and employees doing work for the university, be it teaching, research, or administrative work that benefits the university and public at large.
Thank you,
To
Mr.
answer
Reynolds.
any objections, okay, well, I'm here if anyone has any questions. Again, AFT Maryland supports this bill and asks for a favorable report. Thank you.
Thank you, Mr. Reynolds, for representing AFT. Next, we'll hear from Alexandra Hoyle. Alexandra Hoyle.
I'm a research assistant in the computer science department at the University of Maryland. Before beginning at UMD, I was an economic consultant where I worked on forensic accounting projects. This means I audited companies' financial records and built economic models. I'm telling you this so you understand I'm qualified to inform you about the following facts. Fact number one, the University of Maryland pays its graduate assistants far less than any other school in the Big Ten after adjusting for cost of living. Fact two, it misleads graduate assistants about the cost of living in the area. The difference between cost of living and graduate stipends at other Big Ten schools is about $3,000 per year on average. That means that the average Big Ten graduate assistant is paid $3,000 less than what they need to get by. $3,000 is high, but the deficit at UMD, it's over $11,000 per year. To repeat, the minimum wage for graduate assistants at UMD College Park is $1,000 less than the cost of living in College Park. Second, UMD misleads graduate assistants about cost of living in the area. To arrive at the numbers I just shared, we use a well-established third-party cost of living from MIT. In the past, University of Maryland administration has said that we should use their cost of living estimate, not the third-party one. On average,
thank you for your testimony.
proprietary estimates are about $4,000 greater than the third-party cost of living number for
Mr. Hoyle.
UMD's is 4,000 below the third-party one.
Okay, next we're going to hear testimony from Ember McCoy, Fearless Student Employees.
Hi, everyone. I'm here today as a proud member of the Graduate Employees Organization 3550, which is the graduate student union at the University of Michigan. I'm here to support the Maryland graduate students in their fight for collective bargaining based on my own valued experience as a unionized graduate student worker at another Big Ten university. And I want to note that we've been unionized since 1975, so I think it's a little sad that my peers in Maryland have to be here fighting for this right in 2022. Through collective bargaining, Michigan grad students have successfully secured benefits and protections that make my life as a PhD student innumerably better. It is because of and not in spite of these protections that I'm able to continue making progress to my degree. For example, I have relative financial security that allows me to focus on academic work as opposed to finding additional jobs to survive. And I have great insurance that allows me to take care of myself while getting a PhD. And these things are exactly why University of Michigan faculty are largely supportive of our graduate student union, because they recognize the value it brings to students who choose to come to work with them. And they see the way the union protections and benefits draw students to our university and how they give students the financial and emotional security to thrive in their labs.
Thank you, Ms. McCoy, for your testimony. Are there any questions from members of the Appropriations Committee for the favorable testimony witnesses? Next, we'll move on to the unfavorable testimonies. First, we have David Ownby with Towson University.
Thank you, Chair and members of the committee for your attention. I'm David Ownby, Interim Dean of Graduate Studies and Professor of Chemistry at Towson University. Towson University is the largest public university in the Baltimore region with an enrollment of approximately 23,000 students, 3,000 of which are graduate students. TU is currently developing a plan to expand its research and graduate student capacity. At Towson University, the majority of our assistants are master's students, students who will only be with us for about 2 years. Even though they are with us for a short amount of time, it is important that faculty and student develop a professional mentoring relationship that would be limited in a more rigid employee-employer situation that unionization would impose on the building of trust and support between faculty and student. TU utilizes the meet and confer process, and we respect that process. It includes graduate student representation on multiple shared governance committees to ensure their voice is heard. In response to their concerns, TU has increased graduate stipends each of the last years, resulting in a 60% increase for the lowest paid assistants and a 30% increase for the highest paid. We invite all graduate assistants to the meet and confer meetings, including the meeting that we're having tomorrow evening. A large variety of concerns are brought forward, and many times the solutions are already in existence, so we're able to direct students to the appropriate resource. With this, I'll conclude my brief testimony, and I'm happy to take any questions.
Thank you very much, Mr. Ownby. Next, we'll hear from Patrick Hogan, University System of Maryland.
Thank you, Mr. Chair. Good afternoon. Committee members, thank you for the opportunity to testify on HB 751. For the record, Patrick Hogan with the University System of Maryland. You have a written testimony, so I will be brief. I'll also be followed by the Dean from the University of Maryland College Park as well, who can certainly speak more knowledgeably than I can. I just want to share a few quick points from our written testimony. We have approximately 6,000 graduate students at our institutions, and our institutions have worked over the last decade to improve the status of these students. And these are first and foremost students in an educational program. And our main concern is that this would fundamentally change that relationship from one of faculty and student or mentor and mentee to that of employer and employee. These students do receive significant benefits as a graduate assistant. They receive monetary stipends. And in fact, the COLAs that will be going into effect will impact graduate students as well. They receive health insurance and they receive tuition-free education, which is worth on an average
Thank you,
about
Mr. Hogan.
$22,000 annually.
Thank you very much, Mr. Hogan.
I'll defer to our dean to make additional points. Thank you, Mr. Chair.
Thank you. Next, we'll hear from Dean Fetter with the University of Maryland.
Thank you. You have my written testimony, so I'd like to address the core question, which is why shouldn't GAs have the same rights as other employees, including collective bargaining? When we hire a faculty or staff member, we do a nationwide search to find the most qualified candidate with training and experience in teaching and research. We offer them a salary that reflects that training and experience as well as their performance, and we work to retain them and hope they'll be with us for decades. But we offer graduate assistantships only to full-time graduate students, mostly to PhD applicants to entice them to come to Maryland. The assistantship is based entirely on the applicant's promise as a student. The GA stipend is not compensation for work performed. It's financial assistance to help cover the cost of the degree. That's why the stipend is exempt from payroll taxes and the tuition benefit is entirely exempt from income tax. The stipend doesn't depend on prior training and experience, and all GAs in a unit receive the same stipend regardless of what they're doing, whether their performance is average or superb. An assistantship is part of a student's education. It's not employment.
Thank you very much, Dean Fetter, for your testimony. Now I'll take questions from the committee. Delegate Resnick.
Thank you, Mr. Chairman. I have a question for Dr. Ownby. Dr. Ownby, are you a member of a union?
I am not.
You're not. Are any of the faculty members under your supervision members of a union?
Towson University does not have any unions on campus except our police department.
Interesting. Okay. And do you have any, then what I'll do is I'll defer the question to Dr. Fetter, if I may, Mr. Chairman.
Okay, thank you.
Please.
Thank you, Dr. Fetter. Are any of the faculty under your supervision members of a union?
No.
None. No faculty at your institutions are members of a union.
I don't believe so. There are some staff who are.
Okay. So your argument about doing nationwide searches to get the best and brightest in, where chances are your staff who are members of a union, you don't do nationwide searches for them, do you?
It depends on the nature of the position. For high-level positions.
Which staff are members of a union?
I'm actually not the best person to ask about that. Maybe Patrick Hogan.
Yeah, Delegate, across the system, we have, there are certainly thousands of employees who are part of the union, but the faculty doesn't typically fall under the unions.
Okay, well, it sounds like we have a larger problem than we think, but let me ask this core question, which is what I was trying to get to. The staff that you have at the universities who are members of unions, do you believe that them being a member of a union creates a more adversarial relationship than with their employers?
Sorry, is that are you directing that at me or Dr. Fetter?
I mean, you're the one who answered the question about union staff. So I'm wondering if you know specifically those staff. Are they adversarial, or are they simply staff who have a certain bargaining position?
I think it's staff with a bargaining position in a bargaining unit. Yeah.
So it's not necessarily ruins a relationship between employer and employee being a member of a union.
No, I don't think so. And that's not the argument that we're making, Delegate. I think we're making the argument that it's an educational program. It's not supposed to be in full employment. It's supposed to be an educational program where the faculty set standards based on what they think makes sense for that curriculum.
Thank you very much.
Thank you. The next question is from Delegate Jared Solomon.
Thank you, Mr. Chair. I guess that question is more directed to maybe the witnesses from our previous panel. Ms. McCoy, if you're still here. And I guess I would just say, to the folks from the university system, we have a lot of work to do on our labor relations with folks. Hands down. I won't beat that dead horse because I think we had that conversation the last couple of sessions, which is why we wound up with the legislation that we had last year. And we know we're still working to improve it. But I guess to Ms. McCoy, did having collective bargaining rights at the University of Michigan, in your estimation, diminish the ability of grad students to work with their faculty advisors or Did it do anything to diminish the University of Michigan's standing as, one of the nation's premier research institutions?
I would say no, it did definitely not diminish the relationship between graduate students and their advisors. I have an incredible relationship with my advisor, and he's also incredibly supportive of our graduate student union. I think most advisors recognize that the union actually brings huge benefits to students because it draws people in to come to the University of Michigan because they know that their role as workers to the university is respected and valued as workers. And it also protects, it also gives them higher stipends, better insurance that allows them to thrive in people's labs. I also think it's important to recognize that not every relationship between advisors and advisees is good. Right now at Harvard, there's 3 women graduate students who are accusing their advisor of extreme sexual harassment allegations, and the Harvard Graduate Student Union is protecting them and upholding the university's stated policies and values. And so I think it's really important that we recognize, one, unions absolutely do not hurt the relationship between advisors and advisees where it's good. And those unions also protect students in situations where they're being really harmed by their advisors as well. And so I think it has multiple benefits across the board that most good faculty really do recognize.
Thank you, Ms. McCoy. I think we need a more collaborative relationship, I think, with our employees and as a whole in our university system. As much as I love our system, I think that is one area that we could definitely see some improvement in. Thank you, Mr. Chair.
Delegate Young is recognized.
Thank you, Mr. Chairman. I'm glad Ms. McCoy brought up how sometimes this relationship with the advisor isn't always a positive one. So I guess I apologize, our representative from University of Maryland. Sorry, Mr. Fetter, I apologize.
Dean Fetter.
If in a mentee-mentor relationship, something that Ms. McCoy had mentioned had happened, like there was an accusation of sexual harassment, what is the current policy associated with dealing with that accusation or dealing with that instance?
That would be referred to our Office of Sexual Misconduct and Civil Rights, and they would conduct an investigation. And that's true regardless of whether.
Oh, that's not the point. So after that, what is the relationship between the mentor and the mentee while an investigation is going on?
We can and have made arrangements for a change in advisor when it's necessary. I would add that the advisor is the dissertation advisor is the graduate assistantship supervisor, most often when it's a research assistantship. And at the University of Michigan and most of our peers, research assistants are not covered by collective bargaining. So that relationship would be excluded. I should say that is one of the features of HB 751 that we find the most problematic, the fact that it does cover research assistantships, because often students are doing their dissertation research as their duties for their research assistantship.
Sure, I appreciate the answer. I think my concern with the fact that we know that there are other systems that have collective bargaining for the graduate assistants and that we don't, is that we talk about this mentor-mentee relationship, but we already know that that's already undermined by the fact that some of these advisors can determine whether someone can continue in their graduate assistantship when some of them are completely financially dependent on these positions and without any way of protection in terms of extreme cases with sexual harassment, or even just less extreme cases. There isn't protections about bringing that to someone's light when the person that you're working with is the sole determiner of whether you can continue on with that graduate assistantship and continue your final graduation with a PhD or master's degree. Thank you, Mr. Chairman. I appreciate it. Thank you, Mr. Chair.
Thank you very much, Delegate Young. Are there any other questions from members of the Appropriations Committee for this panel? Seeing none, that ends the bill hearing for House Bill 751. A few announcements to make. First of all, the full committee will meet tomorrow at 12 p.m. for our public hearing on the public debt, and also the subcommittees will be meeting the rest of the day. Also on Friday, we have a voting session, so please keep in watch for emails regarding the hearing schedule and also for the vote list. On behalf of House Appropriations Committee Chairwoman Maggie McIntosh, the Appropriations Committee, we thank everyone for being part of today's virtual bill hearing. Have a great day. Thanks.